So this is the estate planning webinar hosted by Fort Pitt Capital Group and our guest, Michael Fiffik. So this is a guide to the afterlife of your assets. As you can imagine, we get a lot of questions about this when we're having conversations with our clients and prospective clients. So we like to update this from time to time, and we always like to have some good professionals from the community join us.
But you invited me anyway.
We did.
Yeah.
We couldn't get anybody else. So
Right.
Mike's across the street, so it's pretty easy.
That's right. We've been talking about the afterlife, so we will be using a Ouija board to answer some of the questions today. Is that right?
I didn't bring.
You didn't bring one?
No.
I don't have mine.
You were supposed to bring yours.
I know.
So about our firm, Fort Pitt Capital Group, we are an investment management firm. We do everything in-house. So we like to have our portfolio team. They sit right above us. They're doing research all day long. We leave them in dark rooms. We don't let them talk to the public because they're doing a lot of homework to make sure that our investments are sound. And what we really appreciate is the boutique feel, where we are a large firm that helps out a lot of clients in our community and nationwide. But the service is something that we pride ourselves most in, and that's why you have that boutique feel. And we have a team dedicated to each individual, so that if someone like Paul or myself is out of the office, we've always got somebody here to help you out. We also, as you can imagine, we do a lot of estate planning with professionals like Mike, retirement planning, 401ks for business owners, business consultation, really anything financial. You can come to us, and we either can do it in-house or we can introduce you to somebody who can help you out with that. And I already mentioned the exceptional client service. So that's what we pride ourselves in. So a little bit about myself. I am one of the advisors here. I'm a certified financial planner as well as a certified private wealth advisor. Paul and I are going back and forth to see who can have more letters after the end of their name. So if anybody has any suggestions, please let us know. So part of what this is we look at not just your assets, but your entire financial picture. And there's a lot of complexities there. Estate planning is a big part, insurance planning, tax planning, all of those things go into your financial well-being. So we really enjoy it. When I'm not at work, I'm spending time with my family. And yesterday was a great day, having President's Day off. So took my daughter to the movies, and it's pretty easy to impress little kids. So she was thrilled, had a great day, and a lot of fun there. And I'll introduce our MC, so to speak, Paul Brahan.
Morning, everyone. I'm Paul Brahan. I'm also a financial advisor here at Fort Pitt Capital Group. I'm a certified financial planner, chartered retirement planning counselor, and certified exit planning advisor. Hopefully that explains some of the alphabet soup after my name. I like outside of work to cook, and I love the Steelers. It's my favorite team. We're also joined by Mike Fiffik here, managing partner at Fiffik Law Group. So turn it over to him to let him introduce himself.
Hi, everybody. Mike Fiffik. I'm an estate planning attorney. I also help a lot of small businesses with a wide variety of things in their growth cycle, all the way through to exit and succession planning as well. My law firm is located right here in Braintree, not very far away from Fort Pitt Capital's location, and I have an office in suburban Philadelphia as well.
So we're going to go over how to ask a question. Two different ways to do it. Depends if you're on a device or if you're on a computer. So if you're on a mobile device, there is a Q&A tab at the bottom. Feel free to click on that and then type in your question in the chat box there. It's very similar on a computer. There is also a Q&A box, and you'll go ahead and type in whatever your question is. Again, we're going to go over some frequently asked questions. Before we do so, we're going to give a little bit of background on estate planning, but if you have questions, feel free to ask them there and we'll get to as many as we can.
Okay. So without further ado, we'll go ahead and get started there.
Yeah, so estate planning, I like this. It's a big word. A lot of people attach a different type of a meaning to it. What I like to say is it's really taking care of your family. At its very core, it's taking care of your family. And that's what's great about these guys when they say that they have a holistic approach. They're not looking at you just from a spreadsheet standpoint, right? They're taking a look at you, your life situation, your family, what your goals are. And that is what really estate planning is all about, right? Beyond the spreadsheet, really look at your family situation and trying to talk to you and understand what your goals are and how we can best achieve them.
And you can imagine that, we talk to clients all day, every day, and one of the two most frequently asked questions is, what should I do with my estate plan? And maybe people don't ask it in that sense, but we know they want to take care of their family, want to take care of their assets. It's something that everybody knows they should do, but nobody really knows how to do it until you ask the question. So that's part of Paul and myself's job as well, is to, if folks are not asking us these questions, can we ask a question of them to kind of get the wheels turning?
Right. So why should you even prioritize estate planning? Before I even get into these 5 reasons, what I will say is, here's a good reason. Because if you don't have your own plan, right, as an American, it is your right to have a plan for your family. And if you waive that right, that's what you're doing, you waive your right, the government's gonna have a plan for your family. So it's really a very simple choice about taking care of your family. Do you want to take care of your family, or do you trust the government to take care of your family? It's kind of a rhetorical question. I think we all know the answer to that, right? So here are some other reasons why you might want to prioritize getting your estate planning in place. Your health can change whenever you least expect it. I mean, any of us could walk out the door, get in the car to drive to work and not come home because of an accident or another thing coming up. Not knowing the law. A lot of folks think that they know what's going to happen with their assets whenever they pass away, but there are a lot of misunderstandings about what exactly happens with the government's will, who's going to get your estate, or how those beneficiary forms are going to work if you filled them out 20 years ago and you forgot what you actually put on them, or maybe you didn't put anything on them at all. It's always less expensive to get things done ahead of time than it is to fix it after the mess has happened. So, think about it like managing your health care, right? If you managed all of your health care by waiting until at the very last minute and doing it all in the emergency room, you can imagine how expensive, traumatic, and difficult it would be. Getting it done in advance is preventative. It's less stressful. It's much more organized. So it's super expensive to hire me to fix a problem after you've passed away than it is to get it taken care of and have a plan in place ahead of time. So it's just good. It's a good money decision. Absolutely. Right. So it's not just about your family, right? Estate planning isn't about what happens to your money after you die. It's also about you, right? Estate planning also puts a plan in place for you while you're alive in the event that you can't make your own decisions anymore. You can't control your finances anymore. Something sudden happens in your life that you're temporarily not in control of driving the bus, so to speak. So if for no other reasons, do it for yourself, because part of estate planning is taking care of you while you're still here. And then finally, what kind of a family legacy do you want to leave, right? Do you want to not have a plan in place? Your family legacy will likely be chaos, stress, anxiety. Your family's already dealing with enough after you're gone. Or do you want it to be organized, planful, make your family feel like you really took care of them ahead of time to ease that transition? That's the question at the end of the day. What kind of a legacy do you want for your family?
Absolutely. Now, those are all great things. I mean, it's so much easier if somebody already has a plan in place, because people do come to us in the event somebody passes away, and our first question is, where's the will and that sort of thing. And if people don't have it, or if it's really old, it makes things a little bit more challenging.
Oh, and life is more complicated now than it's ever been. We talk about money, as a plan, but
Right.
A big question that your kids might be asking is, what do you want to have done with your body? Like, do you want a funeral?
Mhm.
Do you want to be cremated? What kind of a service do you want? These are things that you don't really sit down and talk to your family about, but when they're put down in place, boy, is it a stress reducer for your kids. And maybe you've had a family member that did that for you. You know how nice it is to see that plan already put in place, maybe even a prepaid funeral. We also have so many of our accounts that are digital, right? They're in the internet. We have all of these accounts that are controlled by usernames and passwords, and they're beyond, the planning for those go beyond who gets what and in what proportion, right? That's not a question that you can answer so easily, and it's not easy to answer, but what do you do with the data that's on your phone? What do you do with your email accounts or the files that are on your laptop? What do you do with your Facebook account or your LinkedIn? Do you want to live forever and ever online? Or do you want to have some type of a plan to deal with those? I mean, think about how difficult it would be for you to manage a loved one's internet accounts. How difficult that would be to just find them, figure out how to access them, and then what to do with them. It's bewildering, but that's really where we're going, right? In this digital world. It won't be very long until none of us have paper statements anymore, right? So, if you don't tell your family where accounts you have, or who to call, all of this hard-earned savings that you have, it's worth nothing if nobody knows that it exists or where it is or how to access it.
I mean, there's so many considerations here, and it does get very complicated. Like you said, I mean, planning for things that happen while you're alive often gets overlooked as well, not just, after you die.
Totally. Yeah, 100%. So do it for yourself because it's about you too.
Right, absolutely. And just we'll have a clarifying question here. Someone asked about what we were saying about computer share early on before we started it. And it really gets back to what you were saying, Mike, of just making sure that everybody knows where all the assets are, because computer share or other transfer agents, as they're called, who, if you or someone else in your family bought a stock directly, it's not really held at a custodian. A custodian could be Charles Schwab or Fidelity or Vanguard, something like that. Put it in a place like that so that your family can track it down easily rather than having to go through the process of doing that. And I guess this is just for the group as well, because Mike, you and I have worked on cases where maybe somebody doesn't have children. So it's still just as important to have an estate plan in place, because whether you have kids or not, you don't want the state or the government to decide what happens to you or your funds.
Right. Whenever you own those in stocks directly, individually, the transfer agent like computer share that you have to use. You don't think about this, but we do, because we're the ones that have to deal with this from a practical standpoint, right? And one of the things that they almost will do nothing without is a medallion guarantee signature, which, I mean, it's almost harder to find that than it is to find a leprechaun anymore these days.
Sure.
It is a total pain in the rear end to send a form to a client to say, this has to be medallion guaranteed. First thing they say is, well, what is that, right? And then where do you get that?
Yeah.
I mean, good luck. Maybe the local bank branch has one person comes in a month that does that, but it's a rigmarole, basically, so to speak. So anyway, I'm glad somebody asked questions about that. So, a common question, right, that you might be asking, and I think you guys probably get from your clients is, okay, I know that I need to get my estate planning in place. I've heard about wills, I've heard about trusts, what do I need, right? But let's talk a little bit first about what a will and a trust doesn't necessarily, control, right? Because these are estate planning documents that have your plan, that dictate who's gonna manage your affairs, where all that money is gonna go, and what's gonna happen to it after you pass away. But your will or your trust don't control these types of assets. So accounts that you have that are owned jointly, like a bank account or a deed with somebody else's name on it, right? That account itself is going to dictate what happens to that asset after you pass away. Another example is going to be any type of an account that has a pay on death designation or a beneficiary form associated with it, like IRAs, your retirement accounts, your 403B, life insurance, annuities. These are accounts that these guys deal with all the time. I am sure that you're very often talking to your customers about beneficiary forms and how to fill those out. And there are a lot of really important decisions that you have to make whenever you complete those. But understanding that your will or your trust. Don't dictate where that money goes. It's a really important thing to understand. And then assets in a trust, right? Your will is not going to trump the terms in your trust if you're a card player, right? Or vice versa necessarily. So it's important to understand how things are controlled after you pass away.
Absolutely.
Now, I have some folks very frequently say, I don't really need a will because I basically am transferring all of my assets by using one of these devices, like a jointly titled account or a beneficiary form or something like that. I call that DIY estate planning, right? Do it yourself estate planning. And I'm just going to suggest to you that this is one of those areas where folks make the mistake that they think that they know what's going to happen. And oftentimes they really don't, and they make a mistake. So here are some pitfalls of DIY estate planning. First of all, if you don't know what you don't know, right? You can make one wrong decision and it can cost you a lot of money. Here's a common thing that I see, right? For you grandmas or grandpas out there, maybe you've got some accounts that you have opened and they're earmarked for each one of your grandkids, so to speak, right? And you've named that grandkid as the beneficiary of that account. And the mistake that you can make is that in Pennsylvania, at least, and maybe other states as well, depending on where you're calling in from, that money cannot be paid to a person who is a minor, right, under age 18.
Mm-hmm.
There will be a court proceeding that will have to happen in order for somebody to be appointed to be the guardian to receive the money that's in that account until that child reaches at least 18 years of age, right? So it sounded like a good plan in the very, in the outset, right? But because you didn't know about minors not being able to receive that money, now you've got an expensive problem that has to be solved after you pass away. And the court may appoint somebody that you don't know to manage that money. So it's usually a bad idea.
And it's the benefit of working with folks like us is we want to build the team around you. But it's a joint conversation. We have conversations with the estate attorneys. We have conversations with accountants and other professionals because we may be doing something on the asset management side that conflicts with the estate planning side. So if everybody's on the same team, your team, then it makes sure that the entire plan is working cohesively.
Yeah, these guys work collaboratively with your attorney,
Mhm.
with your accountant, with your other advisors. It's really important to have that team approach to everything.
Absolutely.
So another thing that folks often do
Mhm.
in order to do some DIY estate planning is put somebody else's name on an account or a deed. And it may seem like a very simple thing to do. Every week I get somebody saying, I want to put my kid's name on my deed. Oftentimes they want to do that because they want to avoid probate. Maybe they want to try to protect that asset in anticipation of needing nursing care in the future. Who knows? But there are a whole host of other issues that are associated with that, right? When you put somebody's name on an asset, like a deed or an account, you're really creating a partnership. It's now a shared asset at the end of the day. And shared asset means you share control over that. You don't have complete control of that asset anymore, as if you own it. Another thing that happens sometimes is after you pass away, you end up with a bigger tax bill whenever that asset is sold than if you would have transferred that as of the time of death. That's a trading off sometimes a 4.5% Pennsylvania inheritance tax for a 15% capital gains tax, right?
Right.
Now, I wasn't very good at math in school, but I do know that 15% is more than 4.5%, but that's not something that folks think of. So, and there are all kinds of other things that come about with that, that folks don't think about.
We see a lot of times people doing that to maximize FDIC coverage, putting someone else's name on an account to try to maximize the coverage there. And again, it's not always the most efficient way. And that's why, having these conversations openly before trying to DIY plan yourself is really important.
Absolutely. I'll tell you a very quick story. So I had a lady who had an adult special needs daughter, right? And mom was having surgery. And so she knew that she was going to be laid up for a little while. So she said to her sister, I need you to be there to make sure that my bills get paid and take care of my daughter while I'm, recuperating. So one of the things that she did is that she put her sister's name on her bank account in order to manage her affairs. So she made it through the surgery, but she died shortly thereafter, right? Mom definitely would have wanted her entire estate to go to her daughter. And that's really what her estate planning document said. Except that joint bank account was now owned by her sister after she passed away. And sister had other ideas about what she wanted to do with that money. And we ended up having a fight with the sister in order to wrest that money back from her for the benefit of the disabled daughter. That's just one of the things that happens whenever you put somebody else's name on the deed. You never know, what somebody else's ideas are going to be. So
Absolutely.
what's the next one we have? Oh, beneficiary form boo-boos. You guys probably could tell lots of stories about this, right? But I see lots of boo-boos whenever people fill out beneficiary forms, one of which is not filling it out at all, right?
Yes, exactly.
Don't know what to do, or you forget about doing it, but partially completed, stale dated, right? You haven't looked at that sucker for the last 12 years and whoops, you have another kid, or you're no longer married to that person. These beneficiary forms have very little space, right? And so you can't do a lot of contingency planning in a beneficiary form. So part of what we do with estate planning is help folks figure these out so that we don't have a mistake along the way. But we see a lot of this kind of thing. I bet you guys do.
Oh, it's all the time. I mean, when you're driving, wearing a seatbelt, that's the cheapest life insurance.
Yeah.
When you have a 401k or an IRA, putting a beneficiary, that's the cheapest will in that sense. You need to have it, even you need a will, obviously, but you need to have those things in place because it just makes everything easier.
That's right. If you have a will, or if you're doing your estate planning, you want to make sure that the provisions in your will or your trust, whatever it is that you use, work in concert with what your beneficiary forms say. They should be talking to one another and working in a cohesive plan. That's really the ideal situation. So we can talk about that later.
Yep.
Special needs beneficiaries, right? DIY estate planning is definitely not built for folks that have special needs kids or special needs beneficiaries in their lives, right? Leaving money to a person with special needs who is the recipient of government benefits often results in that person being disqualified for a period of time from receiving those benefits. They spend your money down and then they have to go through the reapplication process, which is very onerous for many folks, or they're going to need help with it. So if you have a special needs person in your life that you want to benefit from your estate, there are good ways of doing that. But DIY estate planning is usually not a very good way to accomplish that goal.
Gets to your point of, trying to save a little bit of money up front costs them a lot of money on the back end.
That's right. Absolutely. You can have that money available for that special person in your life to enrich their life and make their life more comfortable and better without impacting their ability to continue collecting benefits.
It goes the same for investing special needs trusts, keeping the tax rates, fairly low and customizing that capital gains budget, is something that we have the ability to do because we're managing assets in-house. But when you try to DIY invest that special needs trust and now you have, a ton of capital gains that you're dealing with and you're paying it at tax rates that are, trust tax rates, you can push yourself or your beneficiaries into a higher bracket.
Trust tax rates, highest marginal rate, right?
Yes.
Highest margin. So if you want to pay lots and lots of taxes, do that. Second marriages, right? Second marriages definitely are not a situation that are fit for DIY estate planning, right? If you're going to leave everything to your surviving spouse, the rule that you should understand is that the survivor gets to make all of the decisions. So once your money goes there, that person gets to decide where it goes. Now, I have a lot of people say, I have complete faith and trust that my spouse will do the right thing about my kids, right? Not our kids, but my kids. to a prior relationship. And, I'm sure that that's probably the case in almost all of those instances. Here's what often happens, though, that I see, right? Surviving spouse at some point along the way loses the ability to make their own decisions. And somebody else steps in and is making the decisions for them. And they don't know your kids, maybe they don't like your kids. And they're gonna make their own decisions about what happens with that money. So if you're in a second marriage, right, or in a second relationship and you've made the decision not to get married, there are ways that you can take care of one another after the first of you passes away, but also make sure that your estate is going to go to your kids or whoever it is that is special in your life. But DIY estate planning just doesn't work very well. So what else do we got? What to talk about?
I mean, we get questions about this all the time. I mean, people ask about the beneficiaries, they ask about wills, and then they ask about trusts and what the difference is. So why don't you shed a little bit of light on that if you could, Mike?
Let's, so a trust is basically, it's a very common analogy, right? We analogize it to a red flyer. Maybe some of you have had one of these. Maybe some of you don't know what it is, and I wish I was as young as you. But I had one of these whenever I was a kid anyway. So some folks ask, should I need a will or do I need a trust? It really depends on what you want to accomplish. A will is the tool that is used to change ownership of somebody's assets into somebody else's name after they pass away, right? So if you have a house that just has your name on it, or a bank account that just has your name on it, right? The only way to change the owner of that account is to have your will designate where it goes, and you go through the probate process. That's the ownership change process, basically, is what it is. There are some delays and there are some costs associated with going through the probate process. So some folks would like to avoid that, right? One way to avoid that is to have a trust, right? A trust is it's a written document, right? That contains all of your instructions on what you want to have done with your money while you're alive and what happens with it after you pass away. A trust only controls assets that are owned by the trust. And so we use the red wagon as an analogy to say that a trust, just like a wagon, can only haul around what's in the wagon. If you don't put it in the wagon, it's not going to haul it. If you don't put it into the trust isn't going to control it. So when you use a trust as your primary estate planning tool, we fund it while you're alive, meaning we retitle your assets into the name of the trust while you're alive. Or for retirement accounts, right? We may fill those beneficiary forms out to send the money to the trust to be managed after you pass away in accordance with what your requirements are. Trusts avoid probate, right? They can be used very powerfully to manage your assets while you're alive. They can be used to protect assets from if you're going to have nursing care at the end of the day. It can shield those assets so they're not considered for purposes of eligibility for medical assistance if you want that to pay for your skilled nursing care. It can protect them from a lien on your assets after you pass away. You can also hold money in a trust for the benefit of your kids, and you can protect it in the event your kids get divorced. That money will not be divided in a divorce, and you can use them to keep the money in your family rather than going to your in-laws. Let's say your child dies and they leave everything that you left them to their spouse. Now that money is no longer in your family. It is in somebody else's family to be used however they want. You might be totally okay with that. Or you might say, I don't know, I don't like that idea. I would rather keep that money in my line and help my other grandkids, along the way. So they're very powerful planning tools that you can use to achieve a wide variety of goals.
And not all trusts are the same, and
Right.
some are more complex and some are very simple. So the term trust is great and thrown around a lot, and through conversation and learning what your goals are, that's how we determine what kind of trust. If you need a trust, then sometimes you may need a revocable trust or an irrevocable trust as well. So
That's right.
you know, this slide, I think, Mike, you're going to kind of talk through the differences
Right.
of a few, you know, the two most common things that we work through.
Right, so we got a little chart here, and we have the attributes of trusts, and specifically a revocable trust, sometimes called a revocable living trust. That, what that means is it's a trust that you create while you're alive, and you transfer your assets into that trust and you manage them while you're living. You have complete control over those assets while you're alive. You can take them in and out of the trust, you can sell them, you can do whatever you want with them, but they're managed within the confines of that trust. So with a trust, you can protect assets in case of disability, right? You can provide for that attribute while you're alive. But with a will, right, a will has no effectiveness while you're alive. It doesn't help you manage your assets while you're alive at all. So it can't provide for asset protection for you in the event of a disability while you're alive. A will can't do that. A will does not avoid probate, right? A trust, that you've already retitled the assets to the trust while you're alive. So after you've passed away, there's no need to retitle the assets in order for them to be managed. They're in the name of the trust while you're alive. They're in the name of the trust after you've passed away. The person who has the power to control them changes, but the title of them doesn't. And then that person has immediate access to that money after you pass away. Doesn't have to get any kind of court approval to do anything, manage it. It can immediately start working on effectuating your plan after you've passed away. So they're more powerful. A will doesn't do that, right? It will only works if it goes through the probate process. So you have to take it to the courthouse, you have to file it, somebody has to be appointed, and you're going to have subject yourself to court supervision over the administration of your estate. We talked about the availability of assets, right? If you pass away and you don't have a trust, you're using a will, nobody has access to your assets until that will has been filed and somebody has been appointed as your executor or your administrator to administer your assets. So they can't do anything with your accounts until they've actually been appointed. You know, that can be a big problem for folks, especially if you don't have a will, you waived your right, and you are going with the government's will, right? So a quick example, right, of a mother who had 6 kids, right? And her only assets that she had, you know, in life were 2 pieces of property. You're right here in Pittsburgh, right? She waived her right to have her will. So she's going to go with the government's will. One of the things that the government's will talks about is who gets to control the administration of your assets after you pass away, right? It's a really important thing that you get to decide whenever you have a will or a trust. You pick who that's going to be. The government's will doesn't pick one person. It says this class of people have the right. And so all of her kids have the equal right to administer her estate, right, after she's done, but they all have to agree. And if they can't all agree, right, then you've got like a little Game of Thrones thing going on where they're going to fight and the court is ultimately going to decide either which one of them does it, or usually what happens is if the family can't agree, the court's going to pick somebody unrelated to you to do it. And that's a very expensive process to go through. You definitely don't want to have that happen because you end up paying me a lot of money to fix that problem that would have been a whole lot less expensive had you took care of it, you know, early on down the line.
Not to mention the amount of time it takes, you know, to deal with that process.
Yeah, in this particular situation, it's still not solved 2 years after grandma passed away. So again, you don't need to re-register your property after death with a trust, but with a will, you have to do that. Now you can appoint a guardian using a will for assets to be received by a beneficiary. The trust does that too. That probably should be no difference. You can use a will to protect assets from creditors after death. So you can have a trust that is included in the in your will, okay, but it doesn't come to life until after you've passed away. And it won't come to life until that will is filed, with the probate court. So it's like putting a seed in the ground. It's not going to come to life and grow unless it's filed with the court. Now, with a revocable trust, once you pass away, that can protect the assets as well, but it's immediately effective. So you can start doing all of those types of things. Taxes, you can use trusts to reduce taxes. So there is some benefit there, and there's usually no court involvement with a trust, but there's always court involvement with a will. So there are some differences, some differences here for folks. It really depends which one of these is right for you, depends on what goals that you want to have. But, if you want to avoid probate, if you favor privacy, if you want to provide for control of your assets while you're alive, a trust is probably a good tool for you to be thinking about.
Absolutely.
Yeah.
It is. So this was a really high level overview of some basics. We have a few questions that were in the chat, which we'll go ahead and answer now, but also we had some questions that we received ahead of time and
we should get those.
Frequently asked questions that Paul and I and Mike hear all the time. So this is a good time to ask questions. I'll stop sharing the screen temporarily and pull it back up before the end there. So Paul, before we get to your questions that we have, I just want to circle back to these. This is a big one about the state of residence. So I guess it's a two-part question. I mean, first, we, as in Fort Pitt, we are able to work with folks in any state. And depending on your situation, it may make sense to work with professionals in that state as well. Mike, how do you work with people who either have maybe another property out of state, or they just happen to live in a different state other than Pennsylvania?
Yeah, now I'm licensed in Pennsylvania. My partner's licensed in New Jersey as well. So we will do estate planning for folks that live in those states. But if your residence is in a different state, I'm going to say you probably need a professional in that state.
Mm-hmm.
Now, if you live in Pennsylvania, but maybe you own like a vacation home in a different state, that's something that we can work with you on. And typically a trust is going to be what you're going to want to use as your tool, because it is not specific to any particular state. If you use a will and you've got assets, physical assets located in separate states, you're going to actually have a probate proceeding in each of those states in order to administer your property. So using a will is in particular not a very good thing to have whenever you've got real estate owned in a variety of states.
Absolutely. And use our professional Rolodex if you live in Florida or Texas or California or something. Chances are we know a couple of people there that can help you out or can point us in the right direction for sure.
Absolutely.
So Paul, this is a question I would like your opinion on as the certified exit planning advisor as well. And Mike, you can provide some feedback. So if somebody owns property, maybe it's business, maybe it's real estate, and they own it with, say a non-spouse, maybe it's a business partner or something like that. What titling needs to be in place to make sure maybe this asset goes to that partner and other assets go to the children, as opposed to maybe children or other people that have no say in that person's business or real estate.
Right, that can be fairly complicated, and there are different strategies with life insurance that you can use, cross purchase agreements. So, both partners are covered. What we don't want to happen is for a spouse to inherit a big chunk of the business and not have any idea of what to do with it, and not be a part of those operations really. Mike, what are your thoughts there?
Yeah, we could have a whole session just on succession planning for small businesses, right? A couple of things that a lot of folks don't realize: if you have a single member business entity, right, you're the only owner, If you don't provide for the disposition of your ownership interest in that business, under Pennsylvania law, your business can actually be dissolved as a matter of law if you don't have a plan for it, right? That's the government's plan for your business, is it gets dissolved. So you don't want to have that happen, right? But you know, if you're a small business owner, you want to have some type of a, well, you want to certainly have a business power of attorney, right? To help manage your business if you become incapacitated while you're alive, right? That's a super important thing to have in place. But after you pass away, you probably want to have an agreement with your co-owners, right? That speaks to what happens when you become incapacitated or disabled, but especially what happens to your ownership interest after you pass away. You know, as a business owner, a lot of your savings are tied up in your business, most likely. So you want to make sure that there's a market for your ownership interest, that your family is going to get cashed out and get the money.
Right.
So you want to have a plan. That's where maybe having some life insurance in place to fund a buyout of some kind can be a really important thing for you to have. And you know that your business interest is going to be bought and your family is going to get money out of it, kind of a thing. But you also just want to have some type of controls over it, right? You know, if I were owning a business with Paul, right? And I might like Paul, but I might not like his wife. And I might not be interested in owning a business with your wife. You know what I mean? Kind of a thing. So you also want to provide for control of the ownership group, kind of a thing. Because whenever a business owner passes away, that can be a traumatic thing for a variety of reasons, right? Your employees are wondering what's going to happen. Your customers are going to be wondering what's going to be happening, kind of. So your business can lose a lot of value very quickly without some type of a plan in place. Maybe that's a longer answer than you needed.
Right, no, it's good, and I'll put a bow on it by saying even simple titling, I mean, joint with rights of survivorship is different than joint with tenants in common and other things, so know how it's titled jointly to know who's going to get it, because if it's supposed to go to your family, you want that to happen. If it's supposed to go to the joint owner, then you want to make sure that's how it is as well.
Yeah.
So we've got a few in the chat that I want to get to as well, but Paul, why don't you hit a few of the ones that are main that we had ahead of time?
We just talked a little bit about trusts versus wills. One of the questions that we got before was what happens if you die with neither? And what are some of the consequences? And I know you talked about that a little bit when we started, but if you can touch upon that again.
Yeah, so, you know, when you pass away, when you waive your right to have a plan for your family, and you're going to rely on the government's plan for your family, you know, some nightmare type situations can ensue as a result of that. Let's say that you're married, right? And you've got kids. The government's will says that your spouse is not going to inherit your entire estate. Your spouse is actually going to split your estate with your kids. And it depends on the share that of the split depends on whether they're your spouse's kids as well, or whether they're kids from a prior relationship that you brought in. Now, that can be a pretty difficult situation if you've got assets that are titled just in your name. Let's say that this is a second marriage and she moved into the house that you already owned and you never put her name on the deed for one reason or the other. Now she's going to have to maybe sell that house. So that house might have to be sold in order to satisfy the 1.5 that your kids are going to get out of that estate. So it can be a particularly difficult situation. And we talked a little bit about the Game of Thrones things that happens, right? Because you don't pick who's going to manage your estate after you pass away. And so now you've got a bunch of people who are vying to manage your estate. There might be a court proceeding that has to ensue. You know, one of the most important things that you need to decide, especially if you have kids that are minors, right? You've got 2 kids that are under age 18. Who is going to take care of your kids whenever you pass away, right? Put them to bed, help them with their homework, take them to soccer practice, you know, whatever it is. That's a very important decision for a parent to make. Who's going to take care of my kids? Who's going to share my values? You know, when you waive your right to make that decision for your kids, it's going to end up a decision that's made by the court. And it might be a family member of yours that raises their hand that says, I'll take care of them. I'm gonna correct all of the bad parenting decisions that Skylar made. And, raise these
Yes.
kids, in some cult somewhere, I don't know, whatever. They may not share your values, kind of a thing. You also get to choose who manages the money that you get for your kids as well. And that can be a really important thing, especially if, you're not married, but you want a chance that your ex is gonna manage that money, probably not.
Mhm.
So these are just some of the things that can happen whenever you, again, waive your right to have your plan in place for your family. And you're going with whatever the government's plan is.
So another question, and again, a few of these we've touched upon, but I thought it would be applicable for everyone on the call. What are some essential estate planning documents that everyone, regardless of net worth, should have?
Yeah, I think you should, at the very least, have either a will or a trust. Typically, if you have a trust, you're gonna have a will as well, just in case you pass away, not having titled all of your assets to the trust. You want to make sure that you've got a way to get those assets to the trust, because the trust will be your primary estate planning vehicle, right? That's gonna do all the work for you. You should have what's called a durable general power of attorney, right? That controls your finances. You'll want to have a medical power of attorney that designates somebody to make medical decisions for you when you're temporarily unable to do that for yourself. And also a living will where you can make end of life decisions for yourself. You'll want to complete your beneficiary forms, certainly, if you have any accounts that are controlled by beneficiary designations. If you have young kids that are under age 18, I'd encourage you to think about, at the very least, having a medical consent authorization. If you leave your young ones with grandma or grandpa or aunt or uncle from time to time, you'll want somebody to make medical decisions for them if they can't get a hold of you, you're on a cruise somewhere or whatever it is. But you can also have a more powerful document, and that's called a standby guardianship agreement. So you can designate somebody to basically have all of your abilities as a parent as it relates to your kids, not just medical decisions, but basically be their custodian while you are temporarily not able. Maybe you've had an accident of some kind, maybe you're on one of the COVID cruises that never came into port, whatever it is, kind of a thing, you can designate somebody to do that. That lasts for at least 60 days, and it can be extended by the court. And the court's going to give a lot of deference to the choice that you've made, right? You get to pick the person who's the one who is taking care of your kids. And then finally, if you really wanted to put a bow on it, I would suggest that you have a digital asset instruction letter of some kind. We have all these digital assets that are out there. You really should have some place, and there are lots of services that you can buy from a subscription standpoint, where you can have your password keeper, all of that in place. But you want to have some mechanism of giving somebody control of that and instructions on what do you want to have done with those accounts, right? Maybe you want all of the files on your laptop to be deleted, right? Because people value their privacy these days. Maybe there's something on there that you don't want anybody to know. What happens with your phone? People keep emailing you after you die. Is it, they just think you don't like them anymore? Or do you want to have some type of a responder? What happens to your social media accounts? These are all things that we really have to be thinking about in this day and age, right? If you have crypto, right? And I don't know whether you guys talk to people about crypto. I'm sure that you encounter them, right?
Right.
Where's your digital keys? Where do you have those? Somebody has to know where that is, because without the digital keys, those assets are totally worthless. So it's more important now than ever to be mindful of what happens with your digital assets when you pass away.
Yep, for sure. Right, so we have about 10 more minutes left, Paul. There are a couple more that are pressing there, and then we'll get to some in the chat as
We'll
well.
wind it down a little bit. Mike, how often should you review and update your estate plan?
I would say probably every couple of years, I would be looking at it. And any type of a life situation that changes, like separation or a divorce or a death in your family, something like that, certainly in those situations. But I would say every 2 to 3 years, you should be sitting down to say, is this still the right thing for us to do? Do we have our beneficiary forms completed? And maybe you've changed
Right.
accounts, maybe you've become a Fort Pitt Capital customer and, you need all of that stuff redone.
Right.
So you should be looking at it every few years, I would say.
And how do you choose the right estate planning professional?
Just call me. No. You should definitely work with somebody that has experience in estate planning. So somebody that does estate planning or elder law. There are a lot of neighborhood practitioners that can prepare a will for you, but it's not really what they focus their practices on. So I think you're gonna, get a shorter list of options and considerations from folks that don't make this the focus of their practice whenever they do that. And you can get good suggestions from your financial advisor. These guys can definitely direct your attention to somebody who is going to be knowledgeable and they know that is going to have the right approach to whatever your situation is.
So you're saying it's not like the show Suits where an attorney can practice in every facet of the law and be an
Yeah.
expert, right?
Doesn't work.
Okay.
It doesn't.
Right.
I wouldn't suggest that. You want to find somebody that actually is an estate planning attorney and elder law practitioner. Then you're gonna really know that you're in the right place. Sure.
A couple of questions in here that we should be able to knock out relatively quickly. Mike, can you just briefly touch on the difference between, say, a trustee, a beneficiary, and an executor of an estate?
Sure. An executor is named in your will. So that's the only place that an executor would appear. So they are going to administer your probate estate, the assets controlled by your will after you pass away. That's what an executor does. A trustee, right, is not an executor. A trustee is the person that's in charge of the trust that you've created. Now, in a revocable living trust that you create while you're alive, you are the trustee. You are the trustee and you are the beneficiary, right? So you're controlling those assets and benefiting from the assets in that trust while you're alive. You can create an irrevocable trust while you're alive and still be the beneficiary and the trustee of that too, in some instances. But the trustee is the person that controls the assets titled to that trust, either while you're alive or after you've passed away, and they're managing that. That's what that's called. An executor is only associated with a will and a probate estate. A trustee is only associated with a trust. Does that answer the question?
It does.
Yeah,
Yes, thank you.
Sure.
Yes. In Pennsylvania, we're one of the few states that have inheritance tax. So just for everybody on the call, if it goes to a child versus a sibling versus, a neighbor, what's the percent difference and who's on the hook for that bill?
Yeah, so in Pennsylvania, inheritance tax does depend on the relationship. So lineal descendants, children, grandchildren, 4.5%, sibling 12%, everybody else in the world 15%, right? So that's the rate. I think it's important to understand transferring assets at the time of death versus making a gift of the assets while you're alive and the tax implications of that. I don't know if one of you guys want to talk about what is referred to as the step up in basis, right? That happens at the transfer on death versus what happens if you've given somebody an asset while you're alive. Giving also includes putting somebody's name on it.
Right.
What do you guys want to talk about that?
And you are able to gift per person $18,000 that doesn't go toward your lifetime exclusion. So, back to what you're saying about gifting, you're able to make those gifts while you're alive that aren't then going to be subject to that inheritance tax. For taxable assets that do pass through probate, you're going to get a step up in basis. So for every asset that you have, you buy it at a certain amount. It can grow to a certain amount or go down. But assuming it goes up, when you pass and leave those assets to someone else on the day of death, they get a step up to whatever the value is at that point. So your beneficiaries are then inheriting it with a stepped up basis, and then paying tax for them is going to be much more manageable.
Do you guys have any clients that you talk to about the qualified charitable distribution from their IRAs. Do you talk a little bit about that? I don't know if
Absolutely.
folks know a little bit about that at all, but.
Yeah, I mean, so there are multiple ways to give. We do have we every year we do a charitable giving webinar. So if you want to learn a lot more about that, tune into that, usually towards the end of the year. But high level, everybody needs to take money out of their IRAs when they hit 73 or older, depending on when you were born. So you can, if you are gifting money, giving it from an IRA is a great way to do that, to help satisfy that minimum distribution and not have that hit your 1040 for taxes. But also giving highly appreciated assets out of a stock account is a good way to do it too. So bottom line, if you're giving with cash, there's probably a better way to do that. So talk with us and we can kind of make sure we do it the right way.
Yeah, so sometimes I find that the practical problem for folks, if you're tithing to your church or you're giving to your church, sometimes they don't have an investment account open. And in order for you to transfer money directly from your IRA to your church in lieu of writing a check every week or every month, right? You might have to talk to your treasurer or whatever to have them make sure that the church has an account that can receive that money. But, why write a check after paying the taxes on it? Just give it directly out of your IRA and let the government, help you with your donation, right? With pre-tax dollars. It works really well.
Exactly. So we will, there's a couple other questions we'll try to knock out. We're about 3 minutes until the top of the hour. We want to give a plug for our next webinar, which is a great one right after this. So this is talking more in depth about trusts. So tune in on the 19th at noon. So we'll get our disclosure up here as well. We do appreciate your time. We do appreciate your questions. I'll say this caveat, if you're a Fort Pitt client and we did not answer your question, then your team will reach out and answer it. And if not, one of us, Paul or myself, will reach out as well. If you have questions for Mike, you're happy to talk with folks and answer questions, because a lot of people aren't sure, do I have enough money to work with Fort Pitt? Do I have enough money to work with an estate attorney? Don't worry about that. Reach out to us. We are happy to have a conversation, and we'll be able to know of each of us, yourself and the group here will be able to understand, is this a good fit, or should we introduce a different individual or different party to help you out? So we appreciate your time today. I'm looking through to see if there's any other quick notes about it. A lot of people do, I guess we can kind of close on this. A lot of people think you have to be a multi-millionaire, 10 million, 20 million to have a trust. And I think that's a little outdated. Maybe people think of trust fund babies. And there are certain trusts, maybe setting up an irrevocable trust where you're trying to get a lot of money out of your estate now while you're alive and the federal exemption is so high. But also you can have a trust just for a regular individual that has a normal single family home and not complex needs, right? It's just about how to transfer it to the next generation.
Yeah, absolutely. I would say, trusts are, asset planning, asset protection very much for the middle class, right? Because, you really have the more modest your estate, the more premium you really should put on protecting those assets, because the cost of a mistake is much bigger for folks of modest means than it is for folks that have lots of money, right? So you really want to do this type of protection and, get a little of your control freak on if you'd like to control things after you're gone for your family, right? To protect it from divorce, to make sure that money doesn't go to the in-laws and stays in your family. To use a trust to protect your assets so that if you do need skilled nursing care in the future, that asset doesn't count for purposes of eligibility, and the state on the back end after you pass away doesn't have a lien on your home in order to get paid back. And so for the money that you will pay to set this up ahead of time, if you need skilled nursing, even for 1 month, and it's paid for by medical assistance, the reimbursement lien that the state will have on your home will be a multiple of the amount that you pay just to set this up ahead of time. So it's a very wise allocation of your money to do planning in advance.
Okay, with that, we are at 1 o'clock. We appreciate everybody's time. Please, if you have other questions, shoot them over. We'll get back to you and help you out. Thanks for your time, Mike. Thanks,
Yeah.
Paul.
Thanks,
Thank
everybody.
you.
Thank you.
And
guys.
thank you, Haley, for setting all this up behind the scenes there.